Joining us now is Alyse Adamson, legal analyst and former federal prosecutor, as well as Gerard Filitti, senior counsel with the Lawfare Project and an attorney specializing in national security law and policy and counterterrorism. Alyse, Gerard, thank you both for being on with us today. All right, so here's the latest, right? We're seeing Judge Boasberg, he's delaying this deadline for info on these deportation flights until tomorrow at noon. I want to read this quote from the DOJ's filing this morning. They say, quote, "The pending questions are grave encroachments on core aspects of absolute and unreviewable executive branch authority relating to national security, foreign relations, and foreign policy." So from what you guys are seeing, is this an encroachment on executive power by the judicial branch, or are they well within their authority here? Alyse?
Yeah, I think that's a good question. And I think that is a determination that needs to be made by the courts. I think this is probably part of the issue is that we are seeing an extension of presidential power, and that may very well be permissible. In this case, the president is invoking a centuries-old law that hasn't really been legally tested. And the way that laws are legally tested is through interpretation through the court system. And so I think that the entity to properly answer the question you've just posed is ultimately going to be the Supreme Court, which is where I think this case is going to ultimately end up.
Gerard?
This case, along with many others, will indeed ultimately end up at the Supreme Court, because I do think we need a lot of clarity on many of the laws that are being used for deportations and for detainment. Ultimately, though, there is a problem here, and there's a conflict between the powers that the president has under the Constitution and a court's right and ability to review those presidential actions. Usually there is more time. Usually there's not a time constraint on these reviews. But when you have deportation proceedings that are taking place under a declaration of basically a wartime, a war emergency, this is what the Enemy Aliens Act is, and the president proceeding with deportations in a very short period of time, it's very difficult for courts to go in and review that. And the question is whether even they should. Now, in the past, they should have, and they have, but ultimately the timeliness of this means that it will need to be reviewed by the court. But in the meantime, we have all these interesting discussions.
All right, we'll get into the interpretation of the law in just a moment. But first, in this entire discussion with the DOJ delaying the release of this information, the issue of state secrets privilege is getting brought up. So, Alyse, explain to us, what exactly is that and how likely is the administration to invoke it?
Right. So it's the administration's right. It's actually the government's right to withhold certain information in the name and the face of national security. And I think that's a very important interest. It's been recognized by the courts. And I do agree that there are circumstances where that's appropriate. I think Judge Boasberg's background, having been part of the FISA courts and other national security matters, is very interesting. He challenged the government back on Monday and said, well, why can't I hear it? Please make a case for why this is national security and sensitive information. And so I think it is going to be interesting after the government finishes their findings to understand their argument for the withholding of this information, which I do think under certain circumstances is appropriate.
Gerard, what do you make of the DOJ saying that this can affect national security?
That's certainly a colorful argument when you're dealing with extradition and relations with foreign nations, and just the mere process of getting other countries to agree to holding detainees or transferring detainees. These are diplomatic arrangements. This is the purview of the president, the executive branch, to carry out foreign policy. And sometimes that involves sensitive information, which would be damaging to our policy if it's disclosed. That being said, I think this is why we see a one-day extension on the judge's deadline and a narrowing of the information that he requested. He's requesting specific information to determine what time flights departed U.S. airspace to assess whether it's the possibility of complying with his order, rather than the initial broader request that he had made for information about these flights.
So I want to go back for a second to the fact that Trump invoked this Alien Enemies Act. Now, that act refers to foreign nations or governments, and then invasion or predatory incursion. That's the language it uses. So we're seeing the Trump administration now arguing that that can be interpreted as gangs and as illegal immigration. How well would such an interpretation hold up in court? Alyse?
Again, I think we're going to have to find out. I think when you take the plain meaning of the words, it's a bit of a stretch to say that there has been an invasion, especially of this particular gang. I don't know the exact numbers that are purported to be within the United States, but to say that it is an invasion in what we currently understand invasion would be a difficult argument. So then it turns on what the interpretation of invasion would be within this context. Is mass immigration or illegal immigration an invasion? It could be judicially interpreted to be so. I think a very interesting question is, could a gang or a criminal organization or even a terrorist organization be said to be a nation or a foreign government, which is what the act is applicable to? I think here the language was that the terrorist organization was working in direction of the Venezuelan government. I think if that is found to be factually accurate, then it would be more applicable for the invocation of this act. I think if they're just a regular gang, a regular criminal organization, it is going to be a harder argument to make under the plain meaning of the words in the statute.
Gerard, how do you read this?
I think the meaning of words changes and evolves over time, and they become more encompassing. What the definition of war is has changed over the years to an armed conflict between states, to now including things that are non-state actors. We've had a war on terrorism. We've had a war on many different things that have been declared and that have been accepted by the courts over the years, just as we have had presidents declaring national emergencies on everything ranging from immigration issues to the climate. I think that the courts will give a lot of deference to this declaration by the president, even though there will be certainly pushback. But ultimately, the way we understand terms such as war has evolved over time, such as to give a credible meaning to the government's attempt to broaden the definition.